Good morning, ladies and gentlemen. Welcome to today's webinar co-organized by the Southeast Asia, China and Latin America IPR SME Help Desk. The topic of today is protecting your business abroad and how EU SMEs can take advantage of the Patent Cooperation Treaty, the PCT, in China, Southeast Asia and Latin America. I welcome you all. My name is Jim Stoopman. I'm the project manager for the China IPR SME Help Desk. And before we continue with the webinar, I'd like to go through a number of technicalities of the platform itself, which allows you to best interact and to raise any questions that you might have during the webinar. So this is the next slide. As you can see, this is a quick overview of the sort of interface that you'll see. It is very important that if you have any questions, that you fill them in the questions section, which is indicated on the slide. You can type in literally any question you might have regarding intellectual property or the PCT in general. And at the end of the webinar, my colleague from the Southeast Asia IPR SME Help Desk, Marta Bettinazzi, will answer these questions, probably in cooperation also with our experts for today. A few words on the help desk services. The EU International IPR help desks are an initiative by the European Commission to inform European SMEs about the importance of intellectual property in third markets, with a specific focus on Latin America, China, and Southeast Asia. The aim is really to give SMEs the tools to make informed and strategic decisions about their intellectual property. And all of the services that we offer are for free. A very quick overview of what we do can be found in this slide. First of all, we have an inquiry helpline. This is an actual email address that companies can write to with any question regarding IP, and they'll get an answer within 3 working days. In addition to that, we've got a website, a landing page with a lot of information available about intellectual property. We've got guides, infographics, podcasts, e-learning modules. So a lot of information freely available to sort of start thinking about how intellectual property applies to your company, to your business, and to your products. We do a lot of trainings and webinars, of which this is obviously an example, but we also travel throughout Latin America, Europe, China, and Southeast Asia to try and reach as many SMEs as possible and make them aware of the importance of strategically thinking about their intellectual property. Now, without further ado, I'd like to take a few words to introduce the experts for today. First, Elio De Tullio, an Italian lawyer, a very long-term expert of the China and Southeast Asia IPR Help Desk, based in Rome with multiple years of experience working with Italian and European clients on matters of pertinence to intellectual property in both Chinese and Southeast Asian markets. And he'll be discussing the PCT relevant issues from the perspective of China and Southeast Asia today. So thank you a lot to Elio for joining today. Our second expert is Elisales, based out of Spain and very knowledgeable about all the Latin American markets with regards to intellectual property. And he will be talking today from the Latin America perspective regarding the PCT. So also thank you very much to Eli for joining us today. And I'd now like to give the floor to Eli, who will briefly start with an introduction on what the PCT is and whether there's such thing as a global patent.
Thank you very much, Jim, for the invitation to participate in this webinar today. Well, first of all, we need to know what is the PCT. The PCT, that is the Patent Cooperation Treaty, is an international treaty with more than 150 contracting states. The PCT makes it possible to seek patent protection for innovations in a large number of countries by filing a single international patent application instead of filing several separate national or regional patent applications. For example, if you are a European company who has filed an European patent application or a national application in your country, and you wish protection for this invention in countries like, for example, Brazil, China, Mexico, Thailand, Taiwan, and Colombia, with the PCT, you don't need during the priority period to file several national patent applications. The PCT also assists applicants in seeking patent protections internationally for their inventions. And this is also important, it helps national patent offices with their patent granting decisions. The PCT applications involve two different phases. First of all, the international phase, and second, the national phase. Regarding the international phase, after filing of the application, an international search report, what we call the ISR, and a written opinion on the invention's potential patentability is established. And this is very important because it's going to give the applicant an idea if the patent is going to be granted later by the National Patent Office. If the applicant continues with applications upon request, and this is very important, an international preliminary examination report on patentability is also established. Applicants may also enter into national phases without requesting the examination report. So the question here is, when do you request the preliminary examination? Well, generally, when the written opinion reveals that the claims should be amended in order the invention to meet the requirements of the patent law, that is novelty and inventive step, and my colleague Elio is going to talk about these requirements later. Finally, during the examination process, the applicant may be asked to give further clarifications to some amendments before the filing report is drawn up. This report contains an opinion on the compliance of the international application concerning its novelty, inventive, and industrial applicability to provide the applicant with a strong basis for evaluating the chances of obtaining the patent. However, and this is quite important, the report has no binding effect. Regarding the national phase, the applicants must enter into national phases in order to seek protections in designated states by paying the national fees and providing additional documents. For example, translations if they are required by the national patent offices. The time limit for entering into national phase is 30 months from the international filing date or from the priority date, if there is any, for many countries. And in some cases, and we are going to see this later, 31 months. The processing of the applications with the national phase is carried out by the national offices according to their national rules. For example, further examination if required. And the international patent applications becomes separate national patents when it is granted in the designated states and subject to the national laws. For example, the protection term could vary from one country to other. Finally, the decision on granted patents is taken by national or regional offices in the national phase. That means that the PCT patent applications can be granted in one country, for example, Japan, and rejected in another country, for example, Guatemala. Next, please. Okay, regarding the advantages of the PCT, we have to say that this treaty streamlines the process of fulfilling the formality requirements. For example, at the time of filing the PCT, the owner of this application does not need to translate the patent applications in different languages. That means that it postpones the major cost associated with seeking multinational patent protections. I think that this is one of the main advantages of the system. Also, the international search report and the written opinion contain important information about the potential patentability of your invention and provide a strong basis for you as applicant to make business decisions about how to proceed in the future. For example, if your invention appears to be not patentable at the end of the international phase, you may abandon the PCT application and you would have saved the cost you would otherwise have incurred by directly seeking protection in foreign countries, appointing local patent agents in each foreign country, preparing the necessary translations, and paying the national fees. Also, one of the advantages is that you may be able to fast-track examination procedures in the national phases in some contracting states that have the PCT patent prosecution highway agreements or similar agreements. And finally, the international applications can be put in order before a national phase, and this is something that we will discuss later.
So I'm requested to talk about disadvantages, unfortunately. And I would say that there are not so many disadvantages for PCT procedure, because usually SMEs, when they start to think to protect their invention abroad, they do not have a clear idea where to go. And so if this is the case, the PCT is the right system, because it is a way to postpone the priority date up to 30 or 31 months from the priority date itself. On the other side, PCT is a procedure. So at the end of the process, it does not issue patent, and this concept is not always clear, because at the end you will not have a patent, but you will only have the possibility, to postpone the protection abroad up to this 30 or 31 months. So you do not get into any substantive examination before national IP offices. So at the end of the day, if your main issue is to save money, probably PCT is not the right way to proceed. On the other side, if you have an urgent matter to conclude, or if you have already an existing real possibility of exploitation in some country, or entry into a negotiation with a licensee or a partner, or somebody who like to get your technology and exploit it in the country of destination, probably it is better to go through the national way. And in this way you can save some costs. Otherwise, the PCT is, let's say, the right way to preserve a worldwide protection of your invention for more than 2.5 years. Next, please. Then another issue is that there are countries that are not yet covered by PCT, like Argentina, Myanmar, or Taiwan. There are some ongoing negotiations, but of course, right now, in order to obtain protection in these countries, you need to go through the national phase. So it is, and in order to go through the national phase, this can be done. This has to be done by 12 months from the priority date. So you SMEs should be very careful in order to consider these countries that are not so many, because PCT members are more than 150 countries, but these few countries should be considered by the 12 months themselves. Then, of course, there is a longer time to obtain the patent, because the entry into the national phase is foreseen after 30-31 months, and from that date, so after 2.5 years, you start the substantive examination of your patent. So you liaise with, and you get into, let's say, a discussion with the national offices that can issue, of course, office action in connection with novelty and inventive step of your invention. And you and SMEs should take even more time in order to nationalize the PCT. So the overall time for obtaining patent rights will be longer. Next, please. Another issue can be the form of the application. So it is highly advisable that the form is the definitive one, since the cost to proceed with amendments of the application could be higher if the original form filed and at PCT level, so at WIPO level, is not the definitive one. Moreover, another issue is that it is not possible to enter the Italian or some other countries like France national phase directly from the PCT, because it is mandatory to first enter into the regional EPO phase, and then after obtaining the European patent, so after that it has been issued, it is possible to validate the European patent in Italy or in France. So in this case, the procedure can be quite long and lasting also something like 7 years and like that. So there are these kind of points to take into account while you are getting to the PCT. Another thing is that, of course, the possible protection in more than 150 countries do not involve that you are already protected. So if there are any infringement or violation, you need to be sure that you have saved money in order to react against this possible infringement. And of course, while your patent is still pending. Next, please.
We have to take into account that only inventions may be protected via, through the PCT by applying for patents and utility models. For example, designs and trademark protections cannot be obtained via the PCT. There are other international conventions dealing with this type of industrial property protections. For example, the Hague Agreement for Designs and the Madrid System for Trademarks. You have to consider that if you want to exploit your patent in a foreign country, most of the time this product would also be covered or protected by trademarks or by trade secrets. So when you are going abroad, you have to think globally. That is, you don't have to take into account only the patent protections, but also to have your trademark register in the country in which you are going to exploit your product. And sometimes, if you are going to look for a partner in those countries, maybe you're going to license the patent to this partner, and in several cases you are not only going to license the patent but also the trade secrets. So think globally, and when we are abroad, we have to have a comprehensive IP portfolio protection. Next.
So let's go now to study some formalities in connection with China and Southeast Asia. The deadline for PCT national phase entry in China is 30 months from the date of priority, and this time limit may be extended for 2 months upon the payment of the required fees. The designation of China is includes also the Hong Kong Special Administrative Region, so you can start the procedure also in Hong Kong, and you can nationalize your PCT also in Hong Kong. In case China is the receiving office, you are required to file the English and Chinese application both. However, after entering into the Chinese national phase, the translation into Chinese of the patent documents must be provided to CNIPA. CNIPA is the new China National Intellectual Property Administration that replaces the previous patent, Chinese Patent Office, Chinese Trademark Office, and also the office dealing with geographic indication, the AQ, SIQ, starting from the beginning of 2019. So now this is the new authority dealing with all IP rights in China. Next, please. As well as for the direct national patent applications, also in case of entering the Chinese national phase from PCT, the application is subject to formal and substantive examination. So it is important that the request for substantive examination must be filed by the applicant within 3 years from the international filing or priority date. Of course, when you enter into the substantive examination, you will be required to clarify, very probable that this happened in China, to clarify some aspect of novelty in case previous patent published worldwide can interfere with your application, or inventive step if it is not sufficiently clear the technical solution and the inventive step of your invention. Foreign applicants must appoint a Chinese agent as representative in order to enter into the Chinese national phase, but it is always advisable to first select EU agent or an agent in the country where you take the decisions, where the head office of your company is, because the agent, the EU agent, will liaise with the local agent, preserving a centralized approach and strategy to the protection of your invention. Next, please. In Southeast Asia, only Myanmar is not the contracting state of the PCT. The deadline for PCT national phase entry in Singapore, Cambodia, Brunei, Laos, Malaysia, Philippines, and Thailand is 30 months from the date of priority. In Vietnam and Indonesia, the deadline for PCT phase entry is 31 months from the priority date. So you need to really have a time schedule prepared in advance in order to not to miss any of these deadlines. Please remember that in Myanmar there is a discussion about the possible adhesion of Myanmar to the main international convention. There is also a new law under discussion, but right now the situation is that there are no updates, effective updates, and on this purpose. Next, please. In some countries, it is necessary, it is mandatory to appoint an agent, like in Cambodia, Vietnam, Brunei, Indonesia, Laos, Malaysia, Philippines, and Thailand. While in Singapore, the indication of an address for service is sufficient, but again, you need to preserve the centralized approach to the protection of your invention. So it is better that you are advised by your EU agent if you are a EU company in connection with what is the best way to proceed. In Singapore, Brunei, Philippines, and Malaysia, the patent application and related documents have to be translated into English, while in the other countries it's required the translation in the relevant national languages like Khmer for Cambodia, Vietnamese, Indonesian, Lao, and Thai. Next. The PCT national phases are conducted by the relevant national IP offices, and the procedure to obtain a patent is substantially the same of a direct national application. So there are no substantial differences in case you proceed with the national application or with the PCT application. Probably in case of a national application, the process can be a little bit faster because you avoid some documents are forwarded to national offices. In general, Southeast Asia offices conduct a substantive examination of the invention, and the request for examinations has to be required by the applicant. So the substantive examination involved an analysis on novelty. So the invention must be new compared to the state of art, to all the inventions and patent applications published or registered worldwide, also compared to the literature and all innovation already communicated to the public and available at any level. The inventive step is the usual legal requirement for patents, and it is related to the capacity of the invention to be a technical solution to very complicated technical problems for an expert in that field. And the industrial applicability involves the capacity of the invention to be reproduced industrially and to be incorporated into an industrial product. Next, please. In Cambodia, Indonesia, Laos, Malaysia, and Philippines, of course, Thailand and Vietnam, there are also the small patents, the simple patents, those that in European Union, in some countries of European Union, are called utility models, or petty patents in Laos, or utility innovations in Malaysia, utility solution patents in Vietnam. So they are small invention with a lower level of inventive step. In general, simple patents cover products and tools that make the application, the optimization of patents, existing patents, or other technical solution easier or more effective. Also, simple patents like utility models should be novel and industrially applicable, but the level, the degree of inventive step required by the law and by the offices is lower. In some cases, the inventive step is not required at all, like in Indonesia, Philippines, Thailand, and Vietnam. And in other cases, the innovation required is lesser compared to a standard patent. Usually, there is no substantive examination of utility models and petty patents. Next, please. So the process for obtaining a simple patent is generally shorter because, of course, there is no substantive examination. However, such patents have a reduced term of protection that goes from 10 to 7 years from the filing date. Some Southeast Asian patent offices, for example, Cambodia or Indonesia, may grant patents in a faster way. The same patent has been granted in countries with more developed IP systems like US, Japan, South Korea, or EPO. There is also the possibility to file an application at the Asian Patent Examination Corporation, the so-called ASPEC, that is a regional patent work sharing program involving 9 of the 10 ASEAN countries, so excluding Myanmar. So in this case, the IP offices share each other search and examination results in order to obtain corresponding patents faster and more efficiently. In some Southeast Asian countries, like Thailand, it is better to apply by the direct national application system rather than through the PCT system in order to obtain a grant of the patent in a reduced time. But usually, if you have an urgency in some countries, you can always opt for the national phase because the PCT, of course, requires a little bit more time. Next, please.
Thank you, Elio. Well, here I think that we should remark that there are some Latin American countries not yet in the PCT, and those countries are Argentina, Paraguay, Uruguay, and Venezuela. And we are going to see later which are the implications of this. Yes, next, please. Well, There are some common requirements and characteristics in Latin America that Elio appointed for China and the Southeast Asia. For example, the deadline for the PCT national phase entry in Latin American countries is 30 months from the date of priority, with some exceptions for countries like Colombia, Costa Rica, and Ecuador. We should also take into account that foreign applicants, that is a European company, must appoint an agent as representative in order to enter into the national phase in most Latin American countries. And it's also advisable to do this because of the requirements of the national patent offices. And finally, the National Patent Office conducts a substantive examination of invention, and the request for this examination has to be required by the own applicant. Next, please. Yes, as I said, there are some Latin American countries non-member of the PCT. So which are the practical implications of this? For example, if you're a Spanish company and you want to extend the protection of your national patent in other countries, you have to consider that during the priority period, that is the 12 months, the year, you can file the PCT application, but if you want protections in countries like Venezuela, Argentina, or Uruguay, you have to file national patent applications. If you don't do that, you are not going to have protections in those countries. Next, please. Well, I'm going to give you a clear example, and this is a real case about a Spanish company dealing in the bioagro sector that wishes to extend the protection of his national patent applications in Latin American countries like Brazil, Mexico, Colombia, Peru, Chile, and Ecuador. First of all, we have to ask ourselves about the reasons to choose these countries. Well, first of all, there could be commercial need for exclusivity there. Also, the companies have to consider the cost to file, to prosecute, grant, and maintain a patent in those countries. And also, it's very important to consider the quality of the IP protection and enforcement, the duration of the examination, and the quality of the examinations. Because today, poor systems will be tomorrow good systems. And I'm going to give you a clear example of this. If you file for a patent application in Brazil, it's going to take at least 10 years to have your patent granted in that country. And maybe in 10 years, the technology covered by the patent is going to be obsolete. So you have to consider when do you expect to have the patent granted in the countries of interest. And here are some tips that we usually give European companies before who have filed for an international PCT application before entry into national phase. First of all, you have to leave enough time, at least 2 or 3 months, to prepare the translation of the international application. In the case of Latin American countries, you have to make the translation into Spanish and Portuguese for Brazil. You need to send your local agent copies of the relevant documents on the file, that is the published international application, the international search report and the written opinion, the international preliminary examination report, and sometimes priority documents. Another important tip is that where you would prefer avoiding paying additional claims fees, you have to prepare your applications and any amendments according to the national practice of the countries you are seeking protection. And finally, and as Elio said before, you have to remember to monitor the time limits for entering into national phase. They apply no matter of delays in the national phase. So if the deadline to file the entry international phase is 30 months, and you don't have yet the international examination report, you have to comply with these 30 months. Next, please.
So before starting with this interesting case in Indonesia, I would like to follow Ellie's suggestion and remind you that it is always advisable to carry out a preliminary patent search before filing any patent. So this is valid for PCT as well. Of course, even if PCT is a procedure that can be requested within 12 months from the priority date, it is always advisable to monitor the novelty and inventive step of your invention autonomously before filing the first filing, or even before filing the PCT application. On the other side, it can be reminded that if no substantive examination has been requested, the examination of your patent in case of infringement will be carried out before the court. So you need to think that if your invention is weak in terms of novelty and inventive step, this the protection could be not effective in case of infringement, and you can have some troubles in enforcing your rights. Let's go to this case. The Belgian entrepreneur that started an activity related to food processing operation called Belsa Food in Indonesia. So during this activity, a plant manager of Belsa Food developed a new solution for the raw material cleaning process, and the entrepreneur started to negotiate with him the possibility to exploit the invention, and offered him a reward sharing scheme for using and commercializing this new solution in the name of the company. The entrepreneur and the manager so discussed this, the terms and conditions of this agreement, since the employment agreement did not include IP clauses in case of invention. In the meantime, the manager applied for a national patent in his own name in Indonesia, and the patent was drafted by a local attorney in Bahasa. Next, please. So at this point, the entrepreneur discovered that the patent filing was done and required the manager to assign the application to Belsa Food. But this was not the case, so the entrepreneur started a court litigation in order to ascertain the ownership of the rights of the patent application. And in the meantime, while the court was the court proceeding was still ongoing, the 12 months for applying for a PCT, so the time limit for PCT passed, and the manager no longer had economic resources to file overseas application within the Paris Convention priority period. So in this case, the court affirmed that Belsa Food had the right to claim the patent application, but at that time the 12 months were expired. On the other side, the new attorney appointed by the entrepreneur found that the patent specifications were not really well drafted, and this, together with the expiration of the priority date, was a big problem for this patent. Next, please. So at the end, the entrepreneur could keep the invention only at national level and could not extend the patent application overseas. In the meantime, the manager developed a new version of the innovative solution and found an investor in order to file a new patent application. We don't know yet how the story has ended, but we have some lessons learned from this story. So first of all, if this has not been agreed and specified differently, it is always advisable to include clauses related to IP rights in employment contracts, of course, involved since the very beginning. So since the first filing, an experienced patent attorney, and use the PCT system in order to postpone and to defer the application deadline for up to 30 or 31 months in order to evaluate the commercial feasibility and not to lose the priority date and have the possibility to extend the protection abroad with the nationalization of PCT as mentioned before. Next, please. Just to wrapping up the what it has been presented today, the PCT is a patent application filing system, not a granting system. So after filing the PCT application, you need to nationalize your patent application. So you need to start a discussion and examination with the national offices in each designated country. It is the possibility, it gives SMEs the possibility to postpone the major costs of nationalization, but also maintenance of patent rights, so extending the protection of the invention, but also allocating differently resources in order to proceed with the substantive examination. Design and trademark protection cannot be obtained by a PCT because there are other international conventions like the Madrid system and the Hague Agreement that allow to start international processes through WIPO. So PCT is only related to patents and utility models. And one of the best tools available when seeking protection is PCT because it is a way to start and to plan a medium long-term strategy of protection of your invention abroad in more than 150 countries. Probably this is my last chart. No, there are another. So takeaway messages. Please use the PCT to defer the application deadline by another 30-31 months in order to evaluate commercial feasibility of the invention. Make sure that the invention and the related documentation are definitive, since the cost to proceed with amendments can be high, and pay attention to those countries that are not yet covered by the PCT, because if you lose the first if you miss the first deadline of 12 months, probably you can miss the possibility to go further with your protection in these countries. So this is another deadline to take into account, at least until all the countries of the world will become member of the PCT system. Next.
Thank you very much, Elio, and Elio, of course, for this this fantastic presentation. I think now I'd like to give the floor to Marta, my colleague in Southeast Asia, who I think has a couple of questions as well. And I'd like to urge the audience as well, if there's any questions, to write them down in the questions section of the chat box. But Marta, maybe over to you.
Yeah, thank you to the two speakers also in my behalf, and welcome also in behalf of the Southeast Asia help desk. So we have a couple of questions from the audience. There is the classical question of if there is a way to estimate the time of the timing, let's say, of the international phase, the first phase of the PCT, how long it will take. You said that is going to be long, but there is a way to estimate how long?
Well, the international service report is delivered generally 5 or 6 months after the PCT application has been filed. So you are going to have this international search report with a written opinion in 5-6 months, and you are going to have a more or less clear idea if your patent is going to be granted in the foreign countries. Yeah, that is I think one of the most important deadline that you have to consider at the time of filing a PCT application.
Okay, thank you. And then there is another question that asks if there is a way to estimate the fees, like we mentioned many times the Madrid system, which gives you an indication of the fees on the WIPO website. There is something similar for the PCT or not?
Well, no, I'm sorry. Yeah, the floor is yours.
Well, there is of course, when you file the PCT application, the payment of the initial fees that amount to 3,000 euros, more or less 3,200 euros. But then the problem, the issue is that you need to start the national phases. So when you start national phases, probably the average of the fees to be paid at each single national office depends, of course, on the national offices, but can be estimated, including attorney's fees, in something like 1,000, 2,000 euros per country, more or less. Of course, this depends on each country. I don't have the figure about official fees for each country, but I remember that there is a fact sheet developed by the China and Southeast Asia IPR SME help desk, in which, and probably on the website, in which you can find official fees per country, so related to China and Southeast Asian countries. So it is online.
Yeah, yes. Thank you. Thank you for advertising the publication. It's true, there is everything there. There is also a guide on patent done by the Southeast Asia IPR SME help desk, and I expect that to be also for the China. So yes, you can always refer to our publication. Thank you, Elio, for reminding that to the audience. Go and see the publication. And the other question,
Marta, I'm sorry.
Yes.
I just want to add something to what Elio said, and is that it's very, very common to receive official actions from the national patent offices. And for example, in some countries, it's very, very common to receive up to 2 or 3 office actions, and you have to deal with these office actions. And this means that you have to hire the IP agents in the foreign countries, and sometimes the cost, the biggest cost of these PCT applications are the answers, the reply to these office actions. And there are some countries in which, for example, one office action, if you consider official fees and the IP agent fees and technical and the fees from the technical staff, it's going to be sometimes between 2,000 and 3,000 euros.
Okay,
yeah,
thank you.
I definitely agree with Eli. For instance, in China, you have to expect 2 or 3 office action, and so in this case, it would be you need to allocate and to save some resources in order to face with these documents.
Okay, thank you. Thank you for the very complete answer. There is a last question, which it's been in reality already said during the presentation, and this is if what I can do if I want to fill an utility model or small patent for via the PCT. Maybe if you want, you can elaborate a little bit of what I can do if I have an invention that doesn't have the inventive step for a general patent, but I would like to seek protection also in those countries that have no small patent, like Singapore, for example, which is a big example actually of exception. If you want to add something on this, on the use of PCT for utility model kind of patent.
Well, first of all, you need to carry out a preliminary analysis before filing even the first filing or the PCT, which countries adopt the utility model or not, and then probably the best way is to liaise with your patent attorney, and he will find the best solution in order to protect the utility model in those countries in which this kind of patents are not in force.
Okay. So thank you. There are no other questions. As my colleague has already, Jim has already said, you are welcome to ask more questions via email to any one of the help desks. And I want to thank you all, our speakers, for participating on this webinar, and to all the participants. A very warm thank you from the IPR Southeast Asia Help Desk. Jim, the floor is yours.
Thank you, Marta. Thanks again, Elio and Eli. A few very short final words. Very important. The IPR SME help desks are there for you. We're there to help you. Today we talked about patents and the PCT, but obviously there's way more out there. If there's any questions, as mentioned numerous times, please do write us. The services and the helpline that we offer are fully confidential, and it's first-line advice on China, Latin America, and Southeast Asia. And we work with a large number of IPR specialists on basically any given industry or sector. So if you have any very specific questions as well, please do not hesitate to contact us. And we'd very much like to stress that these services are there for you. So please make use of them. Last but not least, the mandatory social media slide. Please do stay connected. We're very active on Twitter and on LinkedIn. And we have a blog with very relevant and updated articles on the world of IP, and obviously a landing page with all IP information on Latin America, Southeast Asia, and China. So please follow us to stay up to date on new events, new publications, and new webinars. And we look forward to welcoming you to one of our future webinars. And thank you very much for attending. This recording, as well as the slides, will be available on our respective websites soon, and you'll receive a notification of this as well. So thank you again to the experts and Marta, and thanks again to all attendees for being part of this webinar, and wish you all a good weekend. Thank you very much.
Thank you. Bye-bye.
Bye-bye.